Tonight, the King 5 investigators uncover an ugly tangle of alleged misconduct, lies, and spying that's rattling the Snohomish County Superior Court system.
A Superior Court judge has ruled an officer of the court has been cheating on cases involving children for up to 5 years. As King 5's Susanna Frame reports, the alleged misconduct could affect dozens of adoptions in Snohomish County.
Do you solemnly swear or affirm the testimony you give this court will be the truth, the whole truth, and nothing but the truth?
For the past several months, Snohomish County Superior Court Judge Anita Farris has gone ballistic in open court after evidence surfaced of misconduct by an officer of the court, with Judge Farris accusing the officer of lying under oath, submitting a declaration to the court that's a made-up sham, and using the county email system to commit the crime of theft. The officer is a court-appointed advocate for children caught in the middle of ugly CPS cases when the state is moving to take children away from their parents for good. In Snohomish County, the advocates are known as Volunteer Guardian Ad Litems, or VGALs. It's their job to make sure the child's best interest remains at the heart of the case.
And if there are any other witnesses present there.
But Judge Farris has ruled that last year, a VGAL got caught breaking the rules. According to court documents, this VGAL had been spying on a confidential listserv for nearly 5 years, a group email site meant only for the parents' defense attorneys on the cases, where they communicate about legal strategies in confidential emails meant for their eyes only. So why is this a problem? In these parental rights cases, you have the state of Washington on one side moving to terminate the rights of the parents. On the other side, you have the parents and their attorneys, the ones using that listserv to talk strategy. And in the middle is the child with an advocate who's a VGAL, who's supposed to remain neutral. But the court has ruled in this case the VGAL wasn't neutral, but instead was secretly poaching information from the defense to allegedly help bolster the case for the other side. This would be like a coach secretly slipping game plays to the opposing team.
I'd say the most egregious part is the violation of trust.
Adam Balut is a defense attorney for parents and discovered the breach into the listserv.
We cannot allow the desire to win a case to trump what people's job duties are and what their responsibilities are, especially to kids. The best interest of children can't be pushed aside to win a case.
Court records show the VGAL changed her story under oath about how she got on the site and what she was doing, claiming she didn't open any confidential emails and didn't forward any on. The county checked. In fact, dozens and dozens of emails were opened, many clearly marked confidential, and many were forwarded on.
It's just stunning. I mean, we really did not expect anything like this.
Christy Hedman is the administrator of the Washington Defender Association, the nonprofit that hosts the listserv.
If confidential information is being forwarded on to adversarial parties, then that really undermines the whole credibility of the whole process.
Judge Farris saved her most dramatic language when ruling on the VGAL changing her story about what she did on the listserv in sworn declarations, the judge calling it perjury, a felony, that the declaration is filled with lies. The judge went on to say, I've only used the P word, perjury, once in 23 years on the bench, and it applies in this situation. So what is ultimately at stake here? This VGAL worked on over 100 cases in Snohomish County, and if it is found that there was misconduct on them, those cases could be potentially reopened. That means potentially jeopardizing a child's adoption or other sort of placement. The judges, of course, are the top bosses at any courthouse, and a few days ago the judges at Snohomish County found out, and just yesterday they sent out this terse letter to all the parties in the legal system here saying that we're writing to assure you we're taking immediate action to address some of the issues, and we'll be investigating others to decide what to do. So it sounds like they're taking it seriously and want to do some sort of up and down review.
Does the judge think this is just one bad apple or more of a systemic problem?
She made it pretty clear that this woman's supervisors either knew or should have known about the misconduct with the emails, and she cited a host of other problems within the program, like none of them have been trained with guardian ad litem rules, and none of them really knew kind of about how to handle complaints that came in about VGALs. So it sounds like there are definitely systemic issues according to this judge.
And what, in the meantime, what's happened to this particular guardian ad litem?
They wouldn't really tell me for sure on the phone yesterday, but the VGAL administrator said pretty much confirmed that she's still associated with them, but most likely not working on active cases.
It's like change is coming at some point.
Thanks, Susanna.
Yeah.